Welcome to the second episode, I guess you could say, of our Egg Producers Hour series. Today, Poppy Davis joins us, and Poppy is an egg and food expert, policy advisor. She works with farm organizations around the country to train farmers and ranchers on financial and legal business management skills. Poppy joins us today to talk about a very important topic of family farm and ranch succession planning. Poppy, welcome, and I'll hand it over to you.
Great, thank you. Thank you so much for having me. I don't get to travel anymore, but I guess this is as close as I get to still being able to meet people from different parts of the country. So I'm really glad to be with you today. And this is a really important and interesting topic. I think you all received, when you registered for this, I think you all got copies of a couple of different big spreadsheets. I'm going to actually just give a quick little view of them before I dive into the main presentation. Just make sure that you have access to these. Hold on a second. It's hard to switch back and forth here. And I'm going to share this with you really quickly. This is the sheet that you should have, and you can look at it a couple different ways. And I would just encourage you to skim through this at least while I go through the other slides. And I'm going to talk about the role of this tool. But basically, there's a version that is set up to print for those of you that want to see things on paper. And there's a version that's set up to be seen on your screen. It's sort of set up for screen view. Doesn't matter either way, but the idea is that this is a discussion tool to help you do a self-assessment of where you're at with your readiness, and to help you have conversations with your family about that. So I'm going to walk through some slides, but I also really want to encourage you as much as possible, hit the unmute button and ask questions. It'll make it a much more interesting presentation for all of us. This is really your time. So I just set these slides up to kind of cue up the conversation.
And Poppy, may I add, sorry to interrupt. I should have mentioned this earlier, but for those who do have questions, yes, feel free also in the chat box to just type your question in there too, and we can read those out.
Thank you. It's really hard for me to monitor the chat while I'm going, but please interrupt anytime you want with those chat questions. So the first thing I want to say is what I mean by transition. I had a big misunderstanding with someone a few years ago, because every time I said transition, he thought I was trying to tell him to transition to organic. And I thought he was crazy because I didn't know what he was getting upset about. Because I meant transition as temporary transition of business operations. So it doesn't have anything to do with production. It has just to do with the idea of a temporary transition of the management authority of your business, as opposed to succession, which is permanent. So that's what I mean by these two terms, and that's what I, throughout this conversation, want to be focused on is short term, something can go bad, and you are not doing what you used to do, but it's going to end well, it's all going to be fine, but there's some period of time where you're not doing the things you normally do. Do you have a good, solid plan in place to take you and your family and your business through some sort of a temporary absence? That could be a transition, and that could transition into phasing out to retirement. And then the succession is the permanent long-term plan. And we want to look at both of these things. And we want to look at them together because they really do relate to each other. If you have a good retirement transition plan, your estate plan is going to fall out of that pretty naturally. If you focus on estate planning and don't focus on the transition planning, it's probably always going to be hard, and you might never get to the short-term stuff that's more practical. So really the two together is a good way to go. And the tool that I gave you is really designed to cut through it's really common for people to feel like the estate planning is this huge, difficult.
Join the meeting.
It's this huge, complicated, difficult thing that you have to do. And it's so big and so complicated and so emotional that it's just really hard to ever start and make progress. But a lot of the things in transition are really straightforward, not that complicated, not that emotional, and a really good place to get started. So for retirement and transition, you all know this, cash flow is everything, right? And so retirement is just an extra cash flow problem. How are you going to get cash into retirement and keep your operation going? When you answer that question, you've answered really the essence of how the estate plan is going to follow from that. And then for yourself, a plan to stay active and healthy, and that may mean not being fully retired. Fully understand that. That may absolutely mean that your plan is not to fully retire, but to maintain some active and meaningful role in the business. Doesn't mean you need to retain all your role in the business, right? It can mean an active role mentoring and transitioning the business to someone else. But also related to this idea of short-term, a plan for care if you need it. So that's the medical part of the care, but it's also if you're offline for a while for any reason, who's in charge of business while you're in charge of getting better? And when you get better, are you going to come back to your business and see that it's all in good shape because it was all managed the way you wanted it to be managed while you were gone? Or do you get better and go back to your business and find out that a lot went wrong while you were gone because you hadn't really done the right preparation to be gone? That's what we're really focusing in on. And with these self-assessment tools, there's 2 of them, right? I sent you 4 versions, 2 to print, 2 to look at your computer. The 2 of each are from the owner's side. Do you think you've conveyed the right information to the right people? And then the companion one is from the person who would expect to be receiving that. Do they think that you've conveyed the right information to them, that they would be able to step up in a hurry if they needed to? So estate planning, there's just tons of different ways to approach it. But really I think the essence of it is putting the right people in charge of the right things and making sure they have the right information and legal authority. And the default is just to say, it's equal to all the kids and they'll work it out. And, there's maybe a few families where that is a good solution, but most of the time people are really different and they're already pretty well differentiated into what they're going to be good at, what they're going to want to do, what they're going to not want to do, and what they're not going to be good at. And so there's a lot of room in estate planning to really think about what's really going to work well for the people taking over. In estate planning, for sure, there's a time to address special needs and personal or family goals. So if there's someone in your family who, for whatever reason, isn't able to care for themselves and earn their own living, and estate planning is definitely a time to think about how that person is going to be cared for. And then to ensure peace of mind and maintenance of lifestyle for the survivors. So the peace of mind piece is different from the maintenance of lifestyle because there are plenty of estate plans where the lawyers and the accountants did work out the money, and the money will be there for the lifestyle to be maintained, but they didn't necessarily address the human people side. And so there's still a lot of personal
Join the meeting.
There's still a lot of personal questions and unsettled things for people, so they don't necessarily have peace of mind. So ideally, those two things go together. The wishes are communicated in a way that people have both. And then the final part is where most accountants and attorneys want to start because they don't want to get into any of that person stuff. They just want to go straight to, you want to avoid probate, you want to minimize taxes. That's our goal. And so I just want to, yes, that's super important. We're going to talk about that more in a minute, but probably not the most important thing relative to the importance of just your family's well-being, and probably not the best place to start a conversation with your family because it's really technical. So when we think about transition, it's the legal authority, and that is either in place or it isn't. And if it's in place and it's needed, then the person who has it does what they're supposed to do, does what they're able to do. And if it's not in place, they have to go to the court and become a court-appointed guardian or conservator. So, you know, you can imagine it's a bad day if something bad has happened to you and you're not able to act and function. And now probably the person closest to you who loves you the most, who's having also a really bad day, they can't do what they need to do. They have to go to court and get this extra authority given to them. So the better plan is to have that in place on the front end so that they're still having a bad day, but they don't have to have a bad day and go to court to make things happen. And the same thing with a will or a trust and succession. It's either in place, everyone's named and knows what they're supposed to do, or they have to go to court and have that public discussion with a stranger when they're having probably a really bad day or week or month or whatever the time frame is, but it's not a good time in their life. And that additional step is not helpful for them. So when we think about a plan, it's not a thing. It's not one tool. It's not even really a legal term. A completed plan is, you may have a summary document that sort of checks off all the different pieces of the plan, but the plan itself is going to have many different component pieces. It'll have different legal tools like powers of attorney. It'll have different things like wills and trusts. But if you put the whole thing together, that's the plan that people will follow when that day comes and they have to follow a plan. And again, remember, when that day comes, they're not going to be thinking that straight, right? And it's not a day, right? It's months to recover from that kind of grief. And it's a really good time to have a script to follow, because nobody's brain is working that well when they're coming off of that kind of family loss. So while the plan is in process, which is where, you know, maybe many of you are still like, how do I start? How do I begin to wrap my arms around such a big, big task? And again, I'd point you back to that Excel tool I gave you. What's going to happen as you go through those questions is, as you identify questions where you've got low scores, zeros and ones, I don't have a plan for this very small, very particular thing, and you write down, my goal is just to answer that question, just figure out who's doing that thing. As you start to move those individual questions, this bigger plan will start to come together for you. And that just may be an easier approach than starting with the giant task and working down to the specifics, is starting with the really specifics and working up to the overarching legal tools and strategies. So a little just more terminology and things for you to think about. An agreement is a verbal or written understanding. A legal tool is a formal document. So you can have an agreement with someone that if you go into the hospital, they'll keep the place running for you. And most of you would probably feel like that agreement was just implied in your relationship with your family and your neighbors, and you feel completely confident that if something happened to you, people would absolutely come and make sure the animals got fed and watered and things happened and like things would be taken care of. And that's great. And that's called an agreement. Problem is, at some point, those people doing those things for you and your family don't actually have the legal authority to do that. And so there's a limit to how much they can do, and there's a place in which it's going to run into some trouble. And so the legal tools are what we want you to have in place so that the people that are acting and doing for you have the legal authority to act for you. And that can be temporary or permanent. Doesn't have to be that you pass it over permanently. So when we talk about, on the estate side, the estate is all the assets and liabilities of a person at the time that they pass on. And the will is a valid legal document that expresses the wishes of the person who's passed on. Intestate is when someone dies without a will. And what that means legally, if someone dies without a will, automatically state law comes in and governs what will happen to their estate. There's only two choices, a will or intestate. Will says you say what you want to have happen. Intestate means the state where you live says what's going to happen. There aren't other choices. So if you die intestate, you go through the probate process, and there's a public period of time for people to contest what the application of the state law to your estate. If you have a will, you're still going to go through probate, and that's still a little bit of a public process where the will is made public, and there's a period for public notice. So one of the first planning considerations for many families is avoiding probate because it's a difficult time, and who wants that to be public? You want it to be private. And so the way you make it private is you put everything in a trust. So the will says, give everything to the trust. That's all the will says. You can make that public all day long. You can't tell what it says because it just says it's all in the trust. And then the trust has all the personal and private information that you would want to have. So this is to maintain privacy, but it doesn't avoid the responsibility for paying debts, and it can't be used to hide from creditors. So if there are debts of the estate, there's still a process for the people that are owed money to be aware of that and to be paid. The trust document, the trust itself is a legal mechanism for owning and managing the assets on behalf of one or more other people, on behalf of. So you put all the assets into the trust, and the trust is managed for the benefit of others. And the trust document is the script that you're supposed to follow to manage that trust. My friend Susan Stokes says that she thinks of a trust as a basket, and you place the things in the basket, and then the trustee is holding the basket, and they're reading the trust document, and it tells them how to give the things out of the basket to the people that the basket is for. All right, so don't say I didn't tell you this or I'll get really big trouble. Trusts and program payments can get you in a lot of trouble, okay? Because the way, I'm talking USDA program payments here, they're limited for trusts, that the trust is, if the assets are in the trust, you only get one program payment. So if you have 4 or 5 people that were getting program payments and you place everything in a trust, you're down to one program payment now. So you can really mess up a farm, a ranch business by putting everything in a trust. So everything I just said before was general feeling about life, the universe, and everything. If you're an estate attorney, is put it all in a trust. Except if you're a commodity producer and you use USDA program payments, in which case definitely don't do that, right? Because it'll mess up your program payments. So you can still put a lot of things in the trust, but what you can't do is put the farm and ranch operations in the trust, at least not without a solid plan and talking to an attorney who understands federal farm programs and estate planning together, which is a small group of people. And we always hear horror stories of people that thought they were getting the right advice. The attorney sure looked like they knew what they were doing and had a fancy office and maybe even came from a farm state, but maybe they weren't really working with farmers that much anymore. And they missed this program payment piece because it's kind of down in the weeds relative to what maybe they're usually doing. All right. So I'm just going to pause here because I don't want to just keep talking and talking. Are there any questions at this point or comments?
Poppy, who's
That's okay. Yeah.
the best type of person to get in contact with to start the ball rolling, to start the preliminary process to start getting stuff in order? Who's I mean, is it a lawyer or is it financial people, or who's the best type of person to start the ball rolling?
It could be, a little bit depends if you're more interested in thinking about retirement and retirement income, or if you're more interested in really thinking about transferring the whole business to someone else, and estate planning. So I would say for retirement planning, you probably want a financial advisor to help you think about numbers and cash flow. And that's going to lead you over to an attorney really quickly. If you're more thinking I plan on working, I plan on staying healthy, I realize those things may not happen, but my plan is to stay working and stay healthy, and I just need an estate plan because that's the right thing to do, then you probably just want to go straight to an attorney and start that conversation. And that'll lead you back to the other conversation of, well, what if things change and you need someone else to take over? You'll get there.
Yeah.
But in terms of an attorney, if you can, someone close to home, someone in your community, someone who does the estate planning for your friends and neighbors is ideal, if you can find that person. Sometimes in small communities, you may feel like the person in your community, well, there's a few things going on. One, you may know they're an idiot because you know them. Two, they may already know just way too much of other people's business and yours, and you don't really want that to be your situation. So going 1 or 2 counties over is not a bad plan either. But 1 or 2 counties over that are a lot like your county, where like people are still in the same kinds of operations, and they're going to share your values and understand what you're doing, is still your best bet if you can find that person. If you have something really weird and particular going on and they need outside expertise, sort of by definition, they know how to get the outside help if they need it. Whereas when you go to someone who you feel is like very big city, fancy, expensive firm because you've got something complicated built into your estate, but most of what's going on is pretty much straightforward, normal operation. The fancy person may be really good at the really one strange thing you have, but they may really not be good at the whole rest of the part that's just a straightforward farm operation.
Then I also think it's just so important on a couple's screens back about having, if it's a father-son operation, having the son aware of what is going on as far as contracts and leases and rent. And so if an accident does happen, that he's aware of the stuff that needs to be taken care of also, besides just the day-to-day of feeding and putting fertilizer down and that kind of stuff, understanding the kind of the more business side of it.
Yeah, it's really important. And then also having the legal authority, right? So you could definitely have a situation where, both those people, father and son, both know every part of the operation, but the son doesn't have any temporary legal authority. And so, worst day of the son's life is the day he sees dad in hospital, right? And now you also have to go to court and ask permission to do what you're supposed to do. I mean, that's just terrible. So better to have that document just in place, ready to go if needed. All right, so when we think about creating a plan, estate tax is one of the first considerations that comes up. It's only a concern if your estate is above these 11 million or 22 million thresholds. And that's certainly going to involve the attorney who's familiar with estate tax. And again, this is where I want to warn you. A lot of attorneys that are used to dealing with people that are over this income threshold don't know the first thing about farms and farm program payments. So be careful. Be really careful if that's the kind of attorney you need. And maybe think about a team of attorney that's used to high wealth plus an attorney that's used to farms. Property tax is the other big consideration. You're going to need an attorney in state to have a plan for how you transition your property in a way that minimizes property taxes or change in property tax assessment, depending on how you transition that property. One of the biggest considerations in your estate plan is the property tax, how the property taxes may change depending on how you transfer the property. Other things you're going to want to consider, of course, health and disability insurance, and that's a good example of a combination of a financial advisor and an attorney. The financial advisor is going to be better at the specifics of helping you choose what your plan is for health and disability insurance. The attorney is going to be better for reminding you to make sure that different people have the right legal authority to take care of those documents if you can't. Plans for long-term care, Medicaid is another consideration. There's different income thresholds for when you would or would not qualify. And so sort of the overall plan for long-term health maintenance is going to be a fine combination of a financial advisor and an attorney fine-tuning what your family's plan is there. And then again, no one gets to say that I forgot to say how important it is to plan for these farm program payments as a separate piece with someone who knows what they're doing specifically with respect to farm program payments. Okay, the Excel spreadsheet I gave you, what it's really after is starting to get you to focus on these things. Who's in charge of what? Doesn't have to all be the same people. If you have more than one kid, they all want to roll, probably better for them all to have different roles than for them to all have the same role and have to duke it out over that. So who will be in charge of what and who will receive what? And then what are the legal tools to make it happen? Again, the difference between the verbal, informal, and this is so common after someone passes when the children are trying to sort it out. You know, mom always said that was mine. Mom always said I was getting that. Yeah, well, mom didn't write it down and everyone wants that. You know, it's the family dining table. Everybody's got a sentimental attachment and one person's insisting that it was always verbally promised. That's just, it happens in almost every family, and it's not a good thing. It doesn't help people grieve and move on. It exacerbates what's already really hard for people. So the legal tools to make it happen, the specific instructions, and then the informal agreements, again, the knowledge transfers, the informal stuff that has to be transferred, the stories even, right? Did I ever tell you the story of how we got this table, right? Who made it? So the key roles formally, the administrator is the person legally responsible for your estate. The trustee is the person legally responsible for the trust. And the power of attorney is the person who has specific legal powers. They don't all need to be the same. They don't all need to be all your kids. Choose the right person for the job and convey to the other people that giving one person one specific legal role is not about who's loved more or even who's perceived as more responsible or capable. It's about all the things together, who's the best person to do that particular job under those particular circumstances. And it may not be your children. You can think about the children receiving the estate according to whatever plan you work out, and a trusted family friend or advisor holds the role of the administrator, so that the children, there's less opportunity for the children to have to work out their own disagreements and their own sort of, you know, power structure. The decision maker is the trusted family friend or person one removed, you know, maybe aunt or uncle, but someone just outside of that dynamic, and the kids are executing according to those guidelines. And that may be a lot better way to go than just making them all responsible for working it out on their own. I can't give you answers to any of this, right? This is just stuff you have to figure out, but I'm trying to give you some options, right? That you don't, I think a lot of times why people just say everything equal and the kids do everything is they don't necessarily think that there are good options. They feel like maybe placing someone who's outside of the immediate family in that role, like, does it mean there's something wrong with the family, or is that unusual, or is that asking for help in a way that's inappropriate? I don't think any of that is true. It's not uncommon to have an outside person be the administrator for just this very reason. The kids are in a really emotional place right after the death of a parent, it's often really helpful to have someone who's not so devastated there to be a little bit more able to make good decisions in a difficult time. So the power of attorney is a key thing. And when you walk again through this Excel spreadsheet, a lot of the focus is on temporary things. And so you could have a temporary power of attorney just for your business or just for your personal affairs or just for your medical decisions. And it could be very clear that it's just for the period of time when you can't act. You can also absolutely have a permanent power of attorney, but the point I'm making is don't think the second you set up a power of attorney, you've like just completely handed everything over to someone else and you can't get it back. That's not what it means at all. So within the business and back to the assessment, what's really being asked here, you know, is there a temporary or new business manager, a person that's going to be in charge of your business when you're unable to or when you're gone? And then is there a person who has an informal role? Is it fine for that to be informal, or does some part of that need to be made formal so they have the authority to act? So it could even be something like a person who is a close family friend is going to just oversee the part where you distribute the household, the personal possessions of the household. Nothing to do with the farm and the ranch business. They don't have much monetary value, but they're all really sentimental value. And you have a close family person who's just in charge of just making that day that the kids distribute that stuff an okay process and not have it turn into something that leaves bad feelings. So it can be a very, very small role in a certain financial sense, but it's a big role in terms of the emotional impact that it has. So again, back to the tool I gave you, most of the focus on that tool is on the business. Business strategies for business continuity of operations. Some sort of a written plan, who can sign checks, who can run payroll, who can make the loan payment to the bank, who can draw down on the operating loan. I mean, really essential things that may be quite time sensitive. I have a friend, when I was preparing some of these materials a couple years ago, we spent a lot of time talking about her situation. And I said, you know, I just worry about something like being able to run payroll. And she practically burst into tears and she was shaking. She's like, my dad was in the hospital and I was at the office in the dark at night trying to figure out how to run payroll the next day. And she was, you know, she was so afraid for her dad and so upset. And she also knew that the crew needed to get paid. I mean, there are legal reasons the crew needed to get paid, and also the crew needed to get paid because they all, you know, are kind of paycheck to paycheck and had mortgages and such to pay and groceries to buy. So would have been really helpful if she'd already been trained on payroll. Would have been really helpful if she knew where the passwords and codes and such were located, so that she had an easier time of running payroll. And it's little things like that that are sort of examples of easy things you can do now to get started in starting to really work through how it would play out, who'd be in charge of what, do they have the right knowledge and do they have the right authority. So just touch on quickly some of the permanent strategies that you'll be thinking about as you start to think about longer term and about retirement if you're thinking about retirement. Important to be able to distinguish between selling the business and selling the land. And how you structure that is complicated. Midwestern anti-corporate farming laws can complicate this. Farm program payment laws can complicate this. But for the most part, you do want to be able to think about the business and the land as separate. And if you want to transfer those things in two separate ways. And certainly there's different tax and planning and legal implications to transferring the business operations and to transferring the land. Gifts may be part of your plan. And You may think of really creative new solutions like establishing a new entity alongside or within an existing entity. So you may have, first of all, you may plan on living a long time in good health, and that's a reasonable expectation. And you have an adult child who is an adult more than a child, and they're planning on living a long time and being active and healthy too. And it may be the case that the best way to keep going on the same piece of land and get ready for these things is to have them come in with a whole separate new entity that's maybe alongside the existing entity or within it, so that they're not pushing you out of your business, but they're able to get their own business going. And there's lots of ways and opportunities for the two of you to work together, plan together, be familiar with each other's operations that all leads towards being ready for a different transition further down the road, short-term or long-term. And that new entity may be one that is more focused on a higher value product. So there's the ability to get more income off the same amount of land, because that's the key problem in retirement, right? Is if you've only got enough income coming off of the operation to support one family, but you really need to bring two families into the operation, you got to find some way to get that second income to come online, have enough profit for there to be two incomes instead of one. So very likely something in the actual operation needs to change in order for that to happen. So back on the short-term strategies, named beneficiaries. So one of the really expedient things you can do for things like checking accounts is just have them named as a beneficiary just on that account. So it shortcuts past the will and the trust and all the estate planning, and they're just a co-owner of that bank account. You still have to do your estate planning. I'm not letting you off the hook for that, but for that bank account, that person is on it and they can just act. They don't need a power of attorney. They don't need a will. They don't need anything. They're just on it. So it's one way to have your short-term plan come online quickly and easily. You don't need to go through a lot of lawyer stuff to do it. But do understand that that may be a gift and it may be a taxable gift and it may affect your estate plan. So you definitely want to tell the lawyer about it or incorporate it into your plan if you have a more complex situation in your family. Just going to mention here, a protective trust is something you would set up to make sure that someone in your family who can't care for themselves is cared for with your assets. Again, be careful. Protective trust is one of the reasons I have an issue with the limitation on program payments and trusts. Is seems to me like you should be able to get a program payment to someone in the family who needs this kind of protection, but you might not be able to. So this might need some more planning. But just know that this kind of trust is what is used to protect a vulnerable person when you're not going to be around to take care of them. And that is something you're definitely going to want to sit with a lawyer and think through and plan out how that's going to work. Typically, a trust will also have a spendthrift provision. So if your estate plan is going to go to someone not necessarily vulnerable and not able to care for themselves, but maybe very young and maybe not quite ready to inherit money and might spend it all too quickly, it's very common to have provisions in there to make sure that, you know, if someone happens to inherit at peak hormone and peak bad judgment, that's all sort of protected until they get a little older and wiser. So a little bit more on family issues, the idea of equality and fairness. This is typically where people just stop working on their estate plan because they find it too difficult. And they just default to giving everybody equal. And the common outcomes of equal are exactly probably why you're all here, is you know how many farms and ranches and family businesses are lost in that transition, and the children have to sell everything. It's because it came to them all equally, and equal wasn't actually the way that it was ever going to work for that particular group of children. They needed something different. So alternatives to that family meeting. It just really has to be done. Getting together and really knowing what everybody wants, what they prefer, what they intend. And then to transfer the business in a way that certainly to reward anyone who's invested in the business. And to understand, like if someone says, I'm cashing out, you can't change my mind. And someone else says, I want to stay no matter what, you can't change my mind, to plan for that. And that can be planned for, but not planning for it is the hardest way for them to accomplish their goals. So there's just some strategies. Usually one of those strategies is to let the child that's involved in the working operation inherit that working operation, but then have everybody share the land equally. And then the rent payments will go from the working operation to the land. So there's both the equal part of land ownership and the unequal part of owning the operating entity. So you can do equal but different, right? You can spread out different pieces of land and equalize them with cash payments. Sometimes fair is not equal, right? And people understanding the difference between fair and equal, and that it does not have anything to do with how much your parents love you. So we're going to mostly take questions in our last few minutes, but this is just going back to that self-assessment. I hope you've had a chance to kind of skim through it while we're talking. So there's the self-assessment for owners, the self-assessment for the people that would expect to take over from you. A great way to start this ball rolling is just to both do the self-assessment and then see if your answers match up. And any place they don't match up, and there will be places where they don't match up, just start there. Just start there to match that up. You know, you thought you told them this, they didn't think you told them that. Great. Just fix that. That's easy. Then the harder stuff gets harder. So this assessment is broken into these sections. That doesn't mean anything, the particular order. It's just sections that it's broken into to focus on each of these things. The business formation, the land, the accounting and taxation, which, you know, someone has to be in charge of that stuff and know what's going on. Trust me, nobody wants to learn accounting and taxation for the first time in the month after they've lost their last parent. That's not a good plan. Your brain doesn't work when it's struggling with that kind of grief. Labor management, production and marketing, you know, production and marketing techniques and things that you do, relationships that you have that may or may not have been passed on. Credit, cash flow, you know how critical this is. If everything's going great, but the person who's in charge can't access the line of credit, the whole thing comes crashing to a halt. That's not a good outcome for anybody, but it can be easily planned for. And then the insurances in any estate plan, you're going to find insurance plays a very important role. One of the important roles of insurance is to get cash into the hands of the people who need it quickly in the month immediately following losing someone, so they can do what they need to do right away while they make a more long-term plan. So the basic question throughout this whole assessment is if the person that you expect will take over has the knowledge and the authority. Each question is really focused on both the knowledge and the authority. And then the answers are, there is no person identified but doesn't have the knowledge, identifies but has some knowledge but no authority, identified but has some knowledge and authority but not enough, and where you want to be, which is that they're identified and they have the knowledge and they have the authority. So there's like 100 questions on there, but they're all the same question, right? It's all the same set of answers. And this is basically what you're after: the basic legal documents and the basic information, and the plan to get through a short-term period, which is your transition plan, and the plan for the permanent transfer. And then the last thing here is family meetings. Understanding that if you want to move forward on the hard stuff, the easy stuff, you can move forward tomorrow. The hard stuff, you're going to need to have some sort of a family meeting. So we still have a good 15 minutes. I'm hoping we can really open this up for discussion and questions.
Feel free to type your questions in the chat box or go ahead and ask them. Poppy, I'll lead off with a question, I guess, as we talk a lot about trust in your presentation. But can you just kind of help us define the two types of trust that are, I guess, most common that people would know is revocable trust versus an irrevocable trust?
Yeah. So a revocable trust, you can set it up during your life and you can change your mind and it's gone. And an irrevocable trust, once it's set up, it's permanent. Typically, in an estate plan, you set up a revocable trust, which means you can change your mind and get grumpy and disinherit people right up until your last breath. The moment of your death, that trust becomes irrevocable. That's typically the way an estate plan works. Is it's revocable till the moment of your death. The second you're gone, nobody can change that. It's permanent, it's irrevocable. So setting up a trust as part of your estate plan doesn't mean you're locking it all in now and you can't change it. But it typically does mean what you're locking in is the second you're gone, no one can change it.
It seems like just talking to producers, the biggest problem they have is when it comes to splitting up the land. Like I have a friend, and the way they did it is they set up a trust or whatever, and he's got two brothers and sisters. Well, they are going to inherit part of the original farmstead, but then when he came back from college, they bought more land, and his brothers and sisters and mom are getting on them because Matt just gets that because he farmed it and paid for it along with Bruce, because that wasn't part of the original farmstead. So when it comes to splitting up the land and things like that, what advice do you have for people when it comes to that?
I mean, mostly I'd say that's the norm, really, is something complicated like that. That's actually the norm, right? And so the best advice I have is first to, keep the land and the operation separate, know that they are separate and they're going to stay separate. And the plan for transitioning the land should sort of reflect the economic value of the land and the legacy that comes with that. And the plan for transitioning that operating entity should reflect the value of the profits that come to someone who works that land. But, the tricky part, the part that has the family meeting get really hard is the person who inherits the operating entity with insecure land tenure. Like, they know that operating entity is worthless without the land. They can't go somewhere else with that operating entity. It only works on that piece of land. So sometimes people transfer the land into corporations to make it much more difficult to sell the land out. So there are definitely strategies for making it very difficult to sell the land away from the operating entity. And that can be a good thing for the operator. And then it can definitely be perceived as a bad thing for the people that don't want to be tied to the land. So again, back to the hard family meeting and really understanding what everyone wants and intends, and then ultimately deciding which way you're going to go with it. Sorry, I can't give you a more pointed answer, but if this stuff was easy, we wouldn't have talks about it all the time.
Poppy, we have a question in the chat room, a few of them actually. Can you discuss the different kinds of POAs, specifically springing POA?
I can't get real deep into powers of attorney because they're all under state law. And so, that you're going to need to talk to an attorney who's licensed in your state to understand exactly how they work. But I think the point you're trying to get with a springing power of attorney is something that it's automatically activated when certain events happen. So you don't have to go through the process. When you need it, it's activated and it becomes legally valid at that time. But again, I know I can't speak to the specifics because the specifics are really going to be state by state, the terms that are used and what makes them valid and how to get them. What I want you to know is that you have a full range of options and you can basically do a power of attorney for whatever you want, however you want. You just need to go sit with the attorney and say exactly what you want and have them figure that out to do exactly what you want. You can have what you want. You just have to use the right words on the right forms and pieces of paper.
Another question here. A couple will retire in 10 years. They're in their early 60s. The son is 27. And the question is, how do we start transitioning him to management? Someone has informed them of forming an LLC for buying things that they will buy together. Any information on that?
Yeah. So two-part answer. First part answer is that a lot of the how to transition to management is in the checklist because it's a lot of just checklists, individual pieces of information that have or haven't been transferred. Legal ownership of management, that goes into more of the traditional estate plan or retirement plan. If you want to start gifting ownership or if you want to start selling ownership or some combination of gifting and selling, and that typically will tie to your retirement plan, if you need money flowing back to you or not. And so that legal entity formation and how you legally invest the son with ownership shares, that's something I would sit with an attorney, maybe an attorney in concert with a financial planner, to map out if the intention is to make a gift or to have a sale, what kind of entity to form, what effects that will have on program payments. If program payments are part of your financial picture, then make sure however you structure that, you're doing it correctly.
Question here, how do you set things up after a loved one has dementia, especially when they are maybe stubborn or hate losing any kind of control?
I'm sorry, that I don't have an answer for. There are a lot of resources out there about that. There are a lot of good resources on the internet you can find. There's one in particular called A Place for Mom that has a lot of this discussion about what to do after. But mostly I'm here to say, as much as possible, try to get this stuff in place before, because after is a lot harder.
And what did you
And
reference
I
again?
can't, I'm sorry. I know there's one resource that comes up a lot called A Place for Mom. It's just one that I've seen that it has some good discussion for, it tends to have a lot of adult children of parents who already have dementia, and that exact question that you asked. What do I do now that it's already happened and the plan isn't in place? But that is a specialized area, and I don't have any expertise there other than to try as many of you as possible to help you get the plan before you need it, because that's definitely easier.
Can you discuss the pros and cons or differences of a legacy irrevocable trust versus a land company, an LLP, especially in a situation where you're trying to take advantage of estate gifting levels before that could potentially be reduced with the new administration?
I can't discuss that the way you need that discussed, because that's going to be so specific to state law in your area and your individual circumstances. So I'm sorry, I can't go that detailed, but what I will say to that question is if you're already at that place, that's a great place to be when you actually go to sit with the attorney. Probably at that point, you're sitting with an attorney and a CPA together, and you're simultaneously running the numbers for cash flow and tax and looking at the legal long-term implications, and you're doing that planning jointly with a CPA and an attorney licensed in your state. and you're doing it for short term and long term. So it's not really so much the absolute pros and cons, which is why I can't answer the question. It's really the specifics of how it plays out in your state and your operation and your financial situation. And that's what you need to pay an individual professional to be in that confidential relationship with you and actually run those numbers and run those scenarios.
Poppy, can setting up a contract for deed be a good option for transitioning the farm from parents to adult son?
Yes, absolutely. Yes, absolutely can be a good option. Again, beyond saying it can be a good option, I have to send you back to do the specific planning for your specific situation. But contract for deed is definitely one of the tools that can facilitate these things and make them go way faster, way easier, way cheaper, way less complicated than going through the whole elaborate will and trust and all of that. Absolutely.
Poppy, any thoughts about transitioning plans for a farm couple without anyone returning to the operation?
So many thoughts. So many thoughts. You know, first just has to do though with what you want, right? So first it starts out being super personal. What do you want? So I'll just say very broadly, want more than anything is for someone to farm that. Then there's ways to help you find someone who will farm it. And there's ways to get you some help and assistance, both for yourself and for the new person coming on, to make sure they have the right training, support, financial and technical assistance, legal assistance, all that, to make that a successful transfer to a non-family member. You may have different thing in your heart, which is more like, I just want the proceeds to go to, you know, cause or person or charity X. And I don't care how it's sold. I just want the proceeds to go in this particular way. And then usually you would do that through a trust document, but there's also other elaborate techniques for how you would think about how to transfer that out. I'm not sure what else to say about that. You have options, and it's a good thing to plan for. I mean, if you are specifically thinking about wanting to transfer it to a farmer to be farmed and not so worried about like cashing it out for the benefit of a charity or another person, if you don't mind, Rocky, if they can email you and put me in touch, because I can definitely get them in touch with a couple of organizations that would be pretty good at helping them facilitate that kind of non-family transfer.
Poppy, we'll probably wrap up with this last question in the chat box. If you don't have long-term care insurance, can you protect land with a revocable trust or contract for deed, or is a irrevocable trust necessary?
That's a state law question I cannot answer. That's a good example of all I can do is give you some general tools and some general language, and hopefully the spreadsheet tool to push you to get started. But that kind of question, you have to go pay a licensed attorney in your state to tell you how state law applies to you in your situation. I'm just trying to make it easier for you to go sit down and have that conversation and get you prepared. So when you go, you're super organized in your questions, which you already are. But you know, if you go through that checklist, maybe more questions fall out so that you're not wasting time. Clock's ticking at $300 an hour. You've got your questions ready to go and you understand the context of those questions, so you can really get your full value from that attorney.
Well, Poppy, thank you so much. And for those in attendance, we've been emailing out the checklist here. If you haven't received it, please let us know. In the chat box, I think Carla said you could email her, carla@sdfu.org, or simply sdfu@sdfu.org would get to us as well. So we'll make sure that those checklists get out. So
And then
Poppy.
if you want, there wasn't a ton of stuff in my PowerPoint, but a little bit of stuff. So if you want, I can send you the PowerPoint and you can also share that with people if you want.
That would be terrific. That would be great. We would love
Yeah,
to
I'll do that right now.
Thank you for that. So we'll, we can get the PowerPoints out as well. So
Great.
Poppy, thanks for joining us today.
Thank you so much. It was a pleasure to be here.
Thanks everybody
Thank
for
you.
joining.
Thank you very much, Poppy, and thanks
Thanks,
for everybody
everyone.
for attending.
Bye.
Bye.